first case of the morning is in-ring name change of B.A.J. In this case, there's no, as you noticed, an appellee, so you'll just have your full 15 minutes. No need to reserve rebuttal time. And the clock, of course, will be up there. You may look at that as you will. And you know the arguments are being recorded. When you present your argument, please make sure you, number one, sit at the podium, that you introduce yourself just for the record. We are recording this. And that you make sure you speak loud enough that you can be heard as well. I believe from your brief you are referring to your client by the initials of B.A.J, so certainly that is acceptable for our purposes for the day. So I will expect that to be the term you use for your client when you discuss identification. The judge has read your brief and ready to proceed whenever you are.
Good morning, Your Honors. May it please the Court. Christopher Immel on behalf of B.A.J, the appellant in this matter. We're here after my client applied for a name change in the Wayne County Probate Court and then asked that that record be sealed. The trial court, after conducting a hearing, decided that there was not adequate proof that the record be sealed. However, we disagree with that decision based on the fact that under ORC 2717.11 requires satisfactory proof. There is no definition of satisfactory proof. The Oxford English Dictionary defines satisfactory as adequate, fair, and tolerable. At the hearing, my client testified to her belief and understanding that as being an individual who has transitioned, that she is at risk of heightened physical harm, threats of violence. In fact, it's well settled and understood through federal court cases and other scholarly works that at least 25% of transgendered persons in the United States were homicide victims in 2017.
Mr. Chairman, I will ask about that because having read the BAM case that you cite, I thought they were citing a human rights report that indicated that there were a total of 25 people who were transgender individuals who were homicide victims, not 25%. It's a tragic number at any number, but 25% seems a lot larger than 25 total.
I would agree that would, and I think the court has indicated properly that whether it be 20 or 5 individuals or 25%, there is still a heightened risk of transgender individuals who face discrimination, harassment, and violence just because of their gender identity. In fact, here the court had waived the hearing notice on the sealing of this record, indicating on the record that this was going to be a private matter and understood the sensitivity of this request.
Counsel, so on that point, what does that mean under the statute? So the court waived the notice, correct?
That's correct.
And so what does that mean? There are two parts of that, A and B, right?
Correct.
There's an application submitted to the court along with that application satisfactory proof, which you started to speak about, that open records of name change or conformity or publication of the hearing notice under 2717.08 of the revised code would jeopardize the applicant's personal safety. Both of the following apply. And then, of course, A is the one that you just referenced. The court waived the hearing notice requirement. What does that mean with respect to B?
I think the court, Your Honor, is exactly right with that. I think what that says then is that if the court orders the name change, the court shall order the records of the proceeding to be sealed. The court did then grant the name change after this hearing. And I believe in the transcript the court said that there was no concern about doing the name change. The court was, I think, already going to grant the name change regardless of the testimony presented at the hearing. So I think the court now is under a requirement to seal the record under the fact that the court acknowledged that I'm waiving this hearing notice, and in fact told my client at the hearing that you don't have to worry, we're not going to publicize the notice of the name change or this hearing. So the court's keenly already aware of the sensitivity of this and how private this name change matter is. My client testifies at the hearing that she has no criminal record, she is not being sued, she does not owe any debts, she is not doing this for any fraudulent reasons or to try to hide. It's in fact that she's doing this out of a safety concern that now once her name has been changed, as the court did, that anybody going back can find this record, can potentially harass, harm not only her, but her 2 minor children. There's testimony in the record of an incident that occurred at a gas station. An individual, while my client's pumping gas, goes, didn't know we had those around here. My client hurriedly finished pumping the gas and left. She didn't feel safe. And I think that in and of itself shows just the sensitivity that the transgender community faces when dealing with some of the public and making these personal decisions and changes in their lives.
Let me ask you, Mr. Newman, just I didn't have a chance to review the whole record yet, so I understand. The hearing that the court did not have public notice for, is that the hearing for the name change, or that a hearing just simply for whether the notice should be, the hearing, the record should be seen?
The court was unclear of that. My understanding of it was that of the name change and also the sealing of the record. None of it was publicized in the local newspaper or anywhere other than just being on the court docket itself, notifying myself and my client of the hearing.
Was there just one hearing?
There was just one hearing. There was just one hearing that day, Your Honor. After the court indicates that I'm going to grant the name change, the only thing to consider today is the sealing of the record. The court then hears from my client, takes her testimony about why the record should be sealed. And I'd also point the court to Superintendent's Rule 45, that while yes, this rule states that public access to these records is the presumption, however, is public policy being served by restricting access? Is there any state, federal, common law exemption? Or are there other factors that support the restriction of the public access? Some of these indicate the risk of harm, individual privacy rights and interests, and public safety. I think, as indicated in the briefs and is known throughout society today, there is that fear of public safety for anybody who has transitioned, and I think it falls directly under Superintendent's Rule 45 that this record should have been sealed. In fact, I'd like to point out to the court that when filing this appeal, there's really no appellee in this matter. I've never had that happen in my career, that there's really no other party to name other than my client as the appellant. So that I think also goes to show that this is a very private matter. And as long as the court hears and has conducted the hearing, understands it's already waived the notice requirement, that there is no criminal record, there's no criminal pending charges, that the court hears of that the intimidation and bullying that not only happened to my client at the gas station, but that happens to the transgender community, that fear is enough. And I point the court to the New Jersey in the matter of the application of TIC-C from the Superior Court of New Jersey, that that court reversed a trial court decision of the sealing of a record of a transgender individual, basically stating that the fear of the harm to that individual is enough, whether there was any harm directed towards that person or whether or not there was any threats of harm made to that person. Just their own personal belief and fear of this name change record being out there and the harassment, potential violence that they could have faced is enough. I'd also point to the court that the Indiana appellate courts have again reversed a trial court's decision where all records are to be publicly accessible. Under the, again, this guise that the general rates of violence to transgendered individuals is high throughout the United States, and that in and of itself is enough to seal this record.
So if we stick with the logic that transgender people are more likely to experience violence and therefore that generalized fear constitutes the ceiling, then wouldn't that, if we ruled in favor of your client, wouldn't that make it mandatory for all of these cases to be sealed?
I don't necessarily think it makes it mandatory, Your Honor.
Because every single transgender person is subject to that same rate
Yes,
of violence.
yes, but does that individual who's coming before this court have a criminal record? Are there any pending criminal charges? Have they been sued for any outstanding debts?
But you can't get your name changed if you have a certain type of criminal record.
Correct.
But in this case, you're saying it's distinguishable because there's no criminal record
There's no
or there's no background that would violate a public policy reason to keep a record.
That's correct, Your Honor.
Are you saying that under the balancing under Superintendent's Rule 45, that 1 and 3 balance in this case would be different than that generalized?
I would, Your Honor, yes. I could, because I think those, the court is required to take under advisement when making that decision, is this appropriate? Is the public's interest in having access to these records, does that outweigh the privacy interest of the individual?
Counsel, is this case, in your view, I know you've dealt with both the statute and you've dealt with the superintendent's rule, but is it properly resolved under just the statute or just the superintendent's rule? What are your thoughts on that?
I believe that it is. I believe that it can be resolved under either one. I believe the court should resolve it under the statute itself first, and then only look to the rules of superintendents if it doesn't fall with under the sealing guidelines of the statute. And I think another important point about this is we look at the criminal sealing statute under 23AP0032, that Ohio gives individuals who have been convicted or charged with crimes the opportunity to seal their records. The statute says that the court's required to weigh the interests of the applicant and against the legitimate needs, if any, of the government to maintain those records. And if that individual's interests outweigh the government's interests, then the record should be sealed. And in fact, if the court fails to do that, that's an abuse of discretion, and that decision should be reversed. So I think this is exactly where we're at here is, again, there's no state of Ohio sitting here by the prosecutor's office or another party. It's my client, the privacy interest. And if the state has indicated that we can allow certain individuals with certain criminal records to have those matters sealed so that that's not following them for the rest of their lives, why should it be any more difficult for a transgendered individual who is seeking to seal the record of their name change than that criminal conviction?
Could you simply, in this case, or as we do with minors, refer to a transgender individual by their initials and just seal the portions of the record that have specific references to full name and satisfy the same concerns that your client has now?
I don't think so. I think the whole record needs to be sealed, and I think there's at least an ironic spot in which I'm standing, because by the fact that we're here before this court asking this court to overturn the trial court's decision and seal the record, this decision is going to be a public decision. So even if my client's name change record is sealed. She understands that this decision is always going to be out there and is always going to be in the public light, and she's made that decision to come before this court and address that, not only for her benefit, but for any transgendered individuals who come after her. So I think there's a huge public policy and public interest aspect of this case that requires, and the court should determine, that requires the sealing of this record to help all of those individuals. And if there's nothing further, Your Honors, I would rest on my briefs at this point. Thank you.
Thank you.
Thank you.
And thank you, Mr. Emmel, for your presentation. As you know, the court will take the matter under advisement and will issue a decision in due course. When that decision is reached, we'll mail that copy to you